Hello, welcome back to Court Clips. I'm Divinity Said, and you might know that Ashley Benefield has requested a new trial. I assume you know who Ashley Benefield is, or you wouldn't have clicked into this, but on the off chance that is not true, she's the ballerina formerly known as the Black Swan. From henceforth, we will be calling her the Black Widow. She has been found guilty of manslaughtering her husband in Florida. And she tried stand your ground. She tried battered spouse. And now she's like, oh my God, the prosecution battered me too. So let's read this, and then we're going to look at some case law. I'm going to give you my opinion. So this was filed, when was this filed? Today is the 18th, so this was filed on Wednesday from Ashley, and it says, Ashley Benefield wants a new trial. Because one, prosecutorial, feels weird, misconduct. The prosecutor's improper and inflammatory remarks during closing arguments prejudiced Ms. Benefield's substantive rights and warrant a new trial. She's married, and she's using her married name, so it should be Mrs. Benefield, I'm pretty sure. I don't know how it works. I guess if you're a widow. I also think, this is a sidetrack, I think Ms. Benefield should be called Ms. Byers from here on out. You killed the person whose last name you have. You didn't give it to your child. Why are you keeping it? It is not yours. Anyway, under Rule 3.600B of the Florida Rules of Criminal Procedure, the court shall grant a new trial if 5, the prosecutor was guilty of misconduct, or 8, for any other cause not due to the defendant's own fault, the defendant did not receive a fair trial and impartial trial. Rule 3.6B5 requires the court grant a new trial where the prosecutor is guilty of misconduct that prejudiced the defendant's substantial rights. Improper prosecutorial comments warrant a new trial where they deprive the defendant of a fair and improper trial, materially contribute to the conviction, are so harmful or fundamentally tainted as to require a new trial, or are so inflammatory that they might have influenced the jury to reach a more severe verdict than it would have otherwise. The defendant's substantive rights are prejudiced if there is a reasonable probability that, but for the remarks, the outcome would have been different. False statements about Douglas Benefield filing sole custody. During closing argument, Chief Homicide Prosecutor Suzanne O'Donnell falsely stated, quote, May 4th, only a few days later, after she files for another injunction, Douglas files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody, but she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it is probably not safe for this child to even be with her, so he files for full custody, end quote. This statement was entirely false and unsupported by any evidence presented at trial. In fact, the court docket shows that it was Ashley Benefield who filed a motion on May 4th, not Douglas Benefield. See Exhibit B. The prosecutor further emphasized this false claim in her PowerPoint presentation. See Exhibit C. Here is the PowerPoint. It says here on May the 4th, Star Wars Day, that Doug filed for sole custody. The improper argument implied the state had information not presented at trial, suggesting Ms. Benefield was going to lose custody of her child, the final motive put forth by the state. Such comments referring to matters outside the record are clearly improper. As held in Williamson v. State, a prosecutor may not refer to facts not in evidence, as it constitutes a form of unsworn testimony not subject to cross-examination. Given the highly prejudicial nature of this false claim about Mr. Benefield seeking sole custody, there is a reasonable probability it affected the outcome of the trial. Moreover, the improper comments deprived Ms. Benefield of a fair and impartial trial, materially contributing to the conviction, and were so harmful and fundamentally tainted as to require a new trial. It seems like they only brought this up in closing. I think it has to be pervasive throughout the trial, this misrepresentation. I'm not sure. We're gonna look into that together. But if they are not citing anywhere except for closing arguments that these two things happened, then this might have hold like not as much weight as maybe it would if they had continually misrepresented it from jump, or maybe they did. I'm not sure. Page 4. Ms. O'Donnell's statements exceeded all acceptable bounds of advocacy and deprived Ms. Benefield of a fair and impartial trial. A new trial is warranted on this grounds alone. Another one. Improper attacks on and belittling of Ms. Benefield's character and identity. The prosecutors repeatedly and improperly attacked Ms. Benefield's character, calling her a manipulator at least 14 times during closing arguments, and claimed she was manipulating everyone, including the jury. They ridiculed her emotional testimony and accused her of lying without evidence. Such vituperative characterizations of a defendant are improper and prejudicial. Let me Google that. Vituperative. Criticism in a cruel and angry way. It's an adjective that describes criticism in a cruel and angry way. It's used to refer to comments or remarks that are full of angry and cruel criticism. The word is formal and often implies a vicious or harsh language. Oh, so he fancy. Okay, guy. Let me read that again in context. Such vituperative characterizations of a defendant are improper and prejudicial. Manipulator and liar are, what was it again? Cruel and angry. Cruel? This bit, okay. For context, one of Ashley's abuses that she suffered at the hands of Doug Benefield was that he threw the cat and it hit the ground really hard. So her level of harsh vituperosity, if that's a word, vituperativeness, is her meters off. And or this guy's is off. I don't know. Someone's vituperative interpretation's fucking jacked. For example, prosecutor Suzanne O'Donnell told the jury, the defendant trying to say he was in a fighting stance, he lunged at me. That is just her once again trying to manipulate the system. She's trying to manipulate you to believe that this was necessary. He was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. That doesn't sound bad to me. Manipulating the system and trying to manipulate you. Okay. During the state's rebuttal closing argument, Assistant State's Attorney Rebecca Freely told the jurors, buying the house, I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Ms. Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but co-parent. Okay, I'm not going to read the closing arguments, but it says manipulation, manipulate. Miss Benefield so clearly got one side of the story or a made-up story. Said she made up a story. This man that I would have, you believe, is abusive, horrible man. They have defamed him up and down. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. It's manipulation, and that's what she does. That's what she's done. The evidence has shown it to you. Let's see what footnote is 6. Okay, so all the footnotes are just going to YouTube so you can watch them say these things. These inflammatory attacks on Ms. Benefield's character serve no purpose but to inflame the minds of the jurors against her. Such arguments are clearly prohibited. The prosecutors also ridiculed Ms. Benefield's testimony, with Ms. Freely stating, you can decide what you think about her testimony. She's a witness like any other. But I would submit to you that was all manipulation. There were no tears. Oh, yeah, that's funny. She did say, she did remind the juror that she was crying for 15 minutes but didn't need a tissue until the judge offered her one. Such vituperative characterizations, harsh and angry and unnecessarily mean, of a defendant are improper and prejudicial. As Gore v. State says, a prosecutor cannot engage in vituperative or pejorative characterizations of a defendant or needless sarcasm, revealing that the prosecutor has abandoned any semblance of professionalism. In the words of one viewer, these prosecutors sound like a couple of high school bullies. Stop. What? Show me what this says. Oh, it's on X. We can go look. X, formerly Twitter. I can't believe it says formerly Twitter. I'm going to zoom in on this. X is, I think if you look at X's business license, it probably says DBA X, formerly Twitter. And that's why everyone has to write it like this. An X user that watched the closing arguments of the prosecution can be viewed at, what is this? Eden_EE. Oh my Lanta. This isn't clickable or I'd freaking go here. Who cares what this person said? High school bullies. A Twitter user called them bullies. Well, I know 2 Discord users have called them damn heroes, so I'm not sure if that's going to be in here. I doubt it. Anyway, where was I here? High school bullies. Still not enough. The prosecutors went even further and claimed Ms. Benefield was lying with no evidentiary support. They said she told defense experts a made-up story, again, without any basis in the evidence. Such attacks on the defendant's credibility are improper, as the court cautioned in Pacifico v. State, where the case against a defendant is weak or tenuous, a prosecutor's contentions that the defendant is a liar could rarely, if ever, be construed as harmless error. Okay, so maybe we're getting to something here by the made-up story, calling her a liar. Experts, a made-up story without any basis. Oh, that was a made-up story, though. Okay, what they're talking about here is at one point she said that Doug was stalking her and that the neighbor said that she was looking through her windows. That is a made-up story. Look at the police report that the neighbor wrote. Because she said she saw a guy. The guy says he lives around here. Now they're in Florida. There's not like fences. If you're in California, you might be like, oh my God, he was in their yard. But she doesn't see the guy. She doesn't know anything. The woman never says he was looking through anyone's windows. So yeah, it was a made up story. And we're also, so calling her a liar would have, I mean, saying made up story is actually a nicer way to say she's a liar. I don't know. That'll be interesting to read. In Rosso v. State, the court held that improper prosecutorial comments will warrant a new trial where the evidence is very close, where a prosecutor refers to testimony or items not as evidence, or where a prosecutor indulges in personal attacks upon an accused, her defense, or her counsel. Okay. Improper speculation about out-of-court conversations. Whole crap. We're only on page 7. I thought this was going to be short. Prosecutor Friel engaged in improper speculation about conversations between Ms. Benefield and Douglas Benefield, stating, first of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Ms. Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but co-parent. They had to have been talking because he said, I have to email Ashley. He wasn't like, they were talking. So I guess I feel like it was implied, but then again, I don't know how the rules work. There was no evidence presented at trial that Ms. Benefield and Mr. Benefield were communicating while the mutual injunction was in effect. Well, the email that we saw Ashley tried to say he was trying to buy a home next to her. And the email from the realtor, actually, he says, I'd rather just rent. Let me talk to Ashley and see what says. They were obviously communicating. They were, I'm sure that implies the state had information not presented at trial. No, sir, you're just very old and you forgot. So, or maybe your guy, O'Keefe, your computer guy, maybe he's the one making your legal arguments. False claims about defense expert testimony. The prosecutor made false claims about the testimony of a defense expert, Dr. Emma Liu. Prosecutor Friel stated, Dr. Liu is a medical examiner. She seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. The defense asked you why she would do that. She did that because she's getting paid to be here. That's why she's here. That's why she's saying those things, and most of them were probably very accurate. There was no evidence presented that Dr. Liu was being paid to testify or that she testified the way she did because she was paid. Ironically, at the time of her testimony, and as this is being written, Dr. Liu has received no fee whatsoever. Oh, they didn't ask that. The prosecutors never even asked Dr. Liu if she was getting paid. The improper argument suggested, without any foundation on the record, the defense had suborned perjury from their expert witness. Such comments are highly... So she was doing this for free. Why? That's interesting. Received no fee whatsoever. I get maybe because Ashley was broke. She couldn't, her mom had to get a loan and ask for money from friends to get this attorney. So there's no extra money. So maybe all of them were free. She should have asked that question. Because since when do experts not get paid? Hey, that's interesting. F, improper appeals to emotion and sympathy. Well, this is rich. The prosecutors made inflammatory arguments clearly designed to arouse the emotions and prejudices of the jury against Ms. Benefield. For instance, Ms. O'Donnell emphasized, afterwards, she runs over to the neighbor's house. Not once do you hear her say to get an ambulance. I don't know if he's still alive. You know, I had to do it, but somebody help him. Not once did you hear any concern that I just shot another human being, regardless of what the facts are. No. And she was the only person armed in the room. Doug Benefield was not armed. He had no weapon. He was laying on the floor dying. And she goes to the neighbors and not once asks for an ambulance. And he dies either on the way to the hospital or at the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable, and she did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Wanted, because after she killed him, what did she get? Sole custody of the child. Interesting. So the fact that they say that Doug filed for sole custody and they're saying Ashley filed for sole custody doesn't change the fact that she went for sole custody on May 4th. Either he did or she did. She wanted sole custody or she was avoiding it. This is interesting. If that's true. This is obviously coming from Ms. O'Donnell, who is allegedly a liar. Such arguments that serve only to inflame the minds of jurors are improper. Closing arguments must not be used to inflame the minds and passions of the jurors so that their verdict reflects an emotional response to the crime or the defendant rather than the logical analysis of the evidence in light of applicable law. And Gonzalez v. State, the courts held that arguments that have no purpose but to inflame the minds of the jurors against the defendant are clearly prohibited. This is something we don't really hear about, just watching the trials, about closing arguments. We don't get to, there's not a lot of objection, but we don't hear of at least when I was still watching lawyers, trials with lawyers, you don't hear a lot of what is allowed to be said. I'm actually kind of surprised that you can't call someone a liar. I hope you can call them a manipulator, but a lot of this is surprising to me that you're not allowed to say certain things to the jury. Okay, improper burden shifting. The prosecutors repeatedly misstated the law of self-defense, telling jurors they need to evaluate whether Ms. Benefield's use of force was reasonable and necessary. For example, Ms. O'Donnell stated, so the real question in this case is, was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have to review it in the back. However, what you will notice are two words that come up all the time in that instruction. Self-defense, justifiable use of deadly force would be, Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those two words, and like I told you a little bit earlier, that's what you need to think of each time you're trying to evaluate whether she used force appropriately. Okay. Ms. O'Donnell further shifted the burden of proof impermissibly in closing arguments when she highlighted and emphasized the incorrect instruction in her PowerPoint. Self-defense, justifiable use of deadly force. Ashley Benefield was justified in using deadly force if she reasonably believed that force was necessary to prevent imminent death or great bodily harm or forcible felony. Okay, which words are wrong? Telling the individual use was reasonable and necessary. Ms. O'Donnell further shifted the burden of proof. In Ashley's mind, in that moment, it had to be those things, and I feel like they proved that they weren't reasonable or necessary. This is a weird argument. During rebuttal closing argument, State's Attorney Rebecca Friel again argued, a reasonable doubt does not mean proof beyond all doubt. The part emphasized here is, I would submit to you that she did, and then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27, 2020? That's exactly what they're trying to prove, because she used a battered spouse defense. And so she's saying, based on our history and based on what I thought could happen and what I've been programmed to think in my mind and what just happened, this was a reasonable assumption and necessary, regardless of weapon, regardless of anything. Like, battered spouse has been used on a woman killing her husband in his sleep, because it became reasonable to do it that way, even though he was sleeping, because of the years of abuse, and necessary because of new abuse, more abuse, and whatever it is. I feel like her attorney missed the heart of the case, and maybe that's why he lost. But as a layman, this feels like a lot of wasted money. But you know what? If he's got all his witnesses to work for free, maybe, or his experts, then maybe he's just like a really good guy and trying to like retire on the pro bono note. This argument improperly shifted the burden to Ms. Benefield to prove her actions were justified. The self-defense jury instruction clearly states Ms. Benefield does not have the burden of proving this, that she was justified in using deadly force. Instead, for you to find the defendant guilty, she must prove beyond a reasonable doubt the defendant was not justified in using deadly force. Oh, you have to prove her actions were not justified, is what it should have said. Oh, my Lanta. Okay. Hey, sometimes words matter this much, so maybe they're right here. As held in Brown v. State and Hernandez Ramos v. State, the state had the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. I see, said the blind man. Okay. A defendant has a fundamental right to present a defense, see Story v. State, and to have the jury properly instructed on the legal defense supported by the evidence. These rights stand for not if the prosecutor can ridicule a defense so presented, denigrate the accused for their determination in raising the issue, and misstate the law in contradiction of the judge's instructions, as the prosecutor in this case did. The error committed by the prosecutor in closing argument therefore deprives Ms. Benefield of her fundamental right to a fair trial. With ample evidence to support the defense of justifiable use of force, it cannot be said that this error was harmless beyond a reasonable doubt. I'm going to disagree with you, sir. 3 loaded weapons in an empty house, his car about to be hooked. None of her story that day made sense. She's ridiculous. H, false representation of wound path. They're literally, this is like, is the spaghetti done? Get out of the way. We're going to throw the whole freaking pot at the wall. The uncontroverted testimony was that the wound path of the fatal shot in the decedent's chest was from front to back, left to right. Such was the testimony of Dr. Vega, the state's medical examiner. That wound path description was confirmed by Michael Haig. Despite that, and using a graphic illustrator never at any prior time shown to the defense, the state, through Assistant State's Attorney Susan O'Donnell, represented to the jury that the wound path was side to side. It was side to side, and it was demonstrated on the stand that the man had to turn to his side for it to enter where it entered. Oh my God, this is such frustrating. This is just like arguing with a child. I don't even. In an even more blatant misrepresentation, Ms. O'Donnell used a graphic depiction to demonstrate that the wound path entered the decedent's right side behind his right arm, traversed his chest in a straight path, and lodged in his back. Not true. This is a flat-out misrepresentation of uncontroverted testimony, which clearly misled the jury. No, dude, it was right. I don't even. Should I pull up a paint and try to show you? Okay, so this is the guy, Mr. Doug. And we're going to put him slightly turned. So here's his body. I'm sure you could tell that he's slightly turned. Okay, shoot. Let me put him from the side. Here's his arm. Here's his shoulder, his neck, his face, his eyeball, his nose. He's wearing a baseball cap, just so you know which way he's facing. Okay. So this is, put his hand here so you know what this is. This is where, this is a bad drawing. The bullet, it goes in here. So if you were to cut, put a line down the middle of him, how do I do this? It's pretty much exact. Damn, I'm so good at this. Okay, if you put a line down the center of him that way and bisect, I don't know what you call it. We'll do it both ways. There's only, I shouldn't put it right here. Okay, we'll do the bullet in red. Oh, I can't move it. Okay, so because he came into this to the right of his right breast, but because it came in front of this line here, it's considered front. It travels through him. Oh, how? I didn't mean to do that. It travels through him kind of like in a sideways manner. I think it like goes right past his spine. The doctor said that even if it doesn't touch his spine, the act of it vibrating past his spine like that would have collapsed him, paralyzed. And it kind of like goes back and does a thing and is lodged here. So they're trying to say he was shot from front to back. That's what the experts say. And they're saying, no, he was shot from front to back, meaning front in front of this line, back because that's where the end bullet was, or the end of the trajectory was, and side to side because it was in the side of the front. Oh, I guess I should have done that on this line. Over to this way. It's so silly that they're going to argue that the freaking bullet went front to back. When the man was on the stand, the lady's like, I'm going to point the gun at you. You turn in your chair until you would have to be where positioned so the bullet would enter you if I don't move.
And side. So if you could just show the jury, where was this entrance wound?
To the best of my recollection, it's in this general area on the side of the chest, and then it goes in, is recovered just under the skin in the back. So if you're sort of the firearm location, it would place the upper body in a vague general orientation like this.
So if you turned your body, can you keep turning until you get to the point where, okay. So that's approximately the positioning of the gun to the body.
For the upper body, yes, I'd have no way of, yeah, correct, yeah.
Oh, that's frustrating. These are the same arguments he made pre-trial. It's like he was always going to do this. He was such a pain in the ass. This was flat out misrepresentation of uncontroverted testimony. Okay, wrong. Cumulative effect. While no single improper comment may require a new trial on its own, the cumulative effect of the prosecutor's numerous improper and inflammatory remarks deprived Ms. Benefield of her fundamental right to a fair trial. As the court stated in Johns v. State, while no one of the comments standing in isolation would have required a new trial, this court must look at the entire trial record when considering whether the comments at issue are of such nature as to destroy the fairness of a proceeding. I just also want to let it be known that he didn't object to any of this at all. When considering the relative lack of evidence against Johns, the character of the evidence that did exist, and the number of improper arguments made by the prosecutor, it is apparent that the prosecutor's closing argument was improper with respect to the neutral arena in which a trial should be held. That's interesting. I'm looking forward to reading the case law that they're looking at. As stated in Chambers v. State, in order to require a new trial based on improper prosecutorial comments, the prosecutor's comments must either deprive the defendant of a fair and improper trial, materially contribute to the conviction, be so harmful or fundamentally tainted as to require a new trial, or be so inflammatory that they might have influenced the jury to reach a more severe verdict than that it would have otherwise reached. Interesting. Another stupid, interesting argument. The only element there that they could reach if they're standing on a step stool would be reach a more severe verdict. But as you know, she was convicted of the lesser. So they didn't come to the more severe verdict. Ugh. Mr. Guy, how much are you getting paid for this? Is it just the last hurrah? Maybe he's getting his last dopamine fix of lawyering before he fucking retires. Holy crap, this guy. I'm sorry for my language, but I'm also not. The prosecutors in this case repeatedly made inflammatory and improper comments attacking Ms. Benefield's character, referencing matters outside the record, making false claims about the evidence, appealing to sympathy, and shifting the burden of proof. Given the nature of the evidence in this case, these inflammatory and improper comments affected the outcome, deprived Ms. Benefield of a fair and impartial trial, materially contributed to the conviction, and were so harmful and fundamentally tainted as to require a new trial. To establish harmless error, the state must show beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively stated that there is no reasonable possibility that the error contributed to the conviction. The state cannot meet that burden here. A prosecutor's concern in a criminal prosecution is not that it shall win a case, but that justice shall be done. While a prosecutor may strike hard blows, she is not at liberty to strike foul ones. The prosecutors in this case clearly failed to honor those precepts. Their conduct also violated the obligations imposed by the Florida bar. In short, the prosecutors exceeded all acceptable bounds of advocacy. It is appropriate here to reiterate the jurisprudential principle expressed in Pacifico that, quote, the cornerstone of our system of justice is the right of an accused to be judged fairly by a jury of his or her peers, end quote. On the record in this case, the repetitious and egregious nature of the prosecutorial improprieties became such a feature of the trial as to deprive Ms. Benefield of that fundamental right. In this regard, the state cannot demonstrate beyond a reasonable doubt that the prosecutor's comments impugning Ms. Benefield and her defense did not contribute to the verdict. Finally, in this case, the prosecutor's references to Ms. Benefield as being a liar, a manipulator, and two matters for which there was absolutely no support on the record, and in a manner both pejoratively and sarcastically, all of which form the basis for Ms. Benefield's motion. Were so invasive and inflammatory, it is questionable whether the jury could put aside the prosecutor's character attacks and decide the case based strictly upon the evidence. Thus, in situations where witnesses' credibility is the pivotal issue, inappropriate prosecutorial comment, which might be considered harmless in another context, may become prejudicially harmful. As emphasized in Bass v. State, when the case presents a two-witness swearing match where there is little or nothing to corroborate the testimony of the witnesses, witness credibility is pivotal, and inappropriate prosecutorial comments, which might be found to be harmless in another setting, may become prejudicially harmful. Because the present case chiefly involved the testimony of Ms. Benefield, the undeniable crucial issue was the juror's perception of her credibility. Identifiable juror misconduct. That's a word I've never read before. Juror 15. Oh, there's her name. Sarah Yvonne Walcott failed to disclose on her questionnaire material information and further concealed material information during her voir dire that would have resulted at a minimum in a peremptory challenge by the defense. Legal standard. Florida court has laid out a three-part test to determine whether a juror's non-disclosure of information during voir dire will warrant a new trial. First, the complaining party must establish that the information is relevant material to the jury service in the case. Second, that the juror concealed the information during questioning. And lastly, that the failure to disclose the information was not attributable to the complaining party's lack of diligence. Any juror who conceals a material fact that is relevant to the controversy is guilty of misconduct, and this misconduct is prejudicial to at least one of the parties because it impairs his or her right to challenge the juror. In criminal cases, of course, the state is also a party. The presumption of prejudice has been said to apply unless the opposing party can demonstrate there is no reasonable possibility that the misconduct affected the verdict. Under the rule, a criminal defendant is entitled to a new trial if a juror's misconduct has prejudiced the defendant's substantial rights. The substantial rights implicated in this case is Ms. Benefield's right to be tried by 6 impartial jurors and her right to challenge the juror for cause or make a preemptory challenge. Thus, it is a duty of a trial court to see that defendants in criminal cases are tried by a jury such that not even the suspicion of bias or prejudice can attach to any member thereof. If there's any reasonable doubt as to whether a particular juror can render an impartial verdict based solely on the evidence presented and the law announced at trial, that juror should be removed, even if the juror affirmatively states that they can be impartial. I wonder what the question was that she lied about or misrepresented or whatever. She failed to disclose and or conceal the fact that 1, she was a victim of domestic battery on February 20th, 2016, when her live-in boyfriend, Albert Ballinger, intentionally slapped her in the face with an open hand 5 times. Let me think. If she got slapped by an open hand 5 times, would this have hurt Ashley Benefield's claim that a guy could slap her in the face? No, but maybe it would make her think, I never thought he'd kill me, or something like that. Her son, Hayden, was charged with felony battery against his pregnant girlfriend on 31st, and Juror 15 was bonded him out. And she was a respondent in multiple petitions for injunction for petition against domestic violence filed by her ex-husband, Charles, seeking protection for himself and their minor child on the grounds similar to those put forth in Ms. Benefield's case against deceased Douglas Benefield. Why would you fail to disclose this? What an idiot. Juror 15 was a respondent in a petition for injunction, DV again. Minor child. Copy of the petition is attached. In part, threatening violent behavior by Juror 15, including cussing, slamming doors, and throwing objects. Oh, this makes sense, actually, because she's, in her mind, she's like, oh my God, domestic violence people don't kill. I never killed. Suicide attempt by her, constant harassment, him and his wife, fear that Juror 15 might harm their son, future suicide, request for supervised visitation. Juror was also responding to another petition for injunction protection. Yikes, Juror 15. 2004 from the same guy. Protection, seeking protection. Copy of petition is just here. Abuse, same thing. Child expressed fear for her to go home. Child abuse report filed. Threats by Juror 15's boyfriend to kill. Child assumes. Okay, yeah. So these are material. You should have maybe started with this. The undisclosed facts are strikingly similar to the prosecution's theory against Ms. Benefield and would have raised serious concerns about Juror 15's ability to be impartial. The domestic violence allegations against Juror 15, including claims of threatening behavior, violence against a child, and concerns about mental stability, mirror key elements of the state's case in this instance. As noted in Fine v. Shands Teaching Hospital and Clinics, the focus should be on the appellant's counsel. On what appellant's counsel would have done during voir dire had the litigation history of the juror been disclosed, rather than on whether the court believed the jurors were actually biased. Okay. That is interesting. Would they have kept her? They won't know. Given the parallels between Juror 15's concealed history and the facts of this case, information implies a bias or sympathy for the other side, which is all likelihood would have resulted in the use of preemptory challenge. The defense would have undoubtedly exercised a preemptory challenge to remove Juror 15 had this been disclosed. I actually agree with Mr. Taylor here. That's kind of bullshit. Why waste your time being a juror if you're going to waste everyone's time and fuck it up? The juror concealed the information during questioning. Juror 15 concealed this information both on her questionnaire and during voir dire. On the questionnaire, complete under penalty of perjury, she falsely indicated that neither she nor a family member had ever been victim of a crime. During voir dire, when asked about child custody issues, DV, and involvement with injunctions, juror 15 remained silent. Maybe she has freaking battered spouse, though. The Florida Supreme Court has held that Juror 15's non-disclosure need not be intentional to constitute concealment. How was that not intentional? Whether intentional or not, Juror 15's omission prevented counsel from making an informed judgment, which would in all likelihood have resulted in a preemptory challenge. The failure to disclose was not due to lack of diligence. The defense exercised due diligence in questioning potential jurors. Both the state and defense asked sufficiently specific questions about child custody, domestic violence, and injunctions. These topics are within average juror's understanding, which Juror 15's failure to disclose cannot be attributed to lack of diligence by the defense. Unidentifiable juror misconduct. Oh, another one. Lastly, although not yet traceable to an identifiable juror, upon information and belief, an as yet unknown juror brought a cell phone into the jury room. Oh, I heard this. Is this where they got that from? Brought a cell phone into the jury room and used it during deliberations, constituting an objective act that compromised the integrity of the fact-finding process and prejudiced Ms. Benefield's substantive rights, requiring a new trial. That is interesting. Facts. During deliberation, a juror brought a cell phone into the jury room and used it while discussing the case with the jurors. The act was in direct violation of the court's instructions, and Florida law prohibiting unauthorized material in the jury room. Cell phone into and used it while discussing the case with other jurors. During deliberations, a YouTube user, That Hoodie Guy, posted comments on the Long Crime Network's YouTube livestream of the verdict watch. These comments contained real-time information that would only have originated from within the jury room, suggesting a breach of court's instructions, the sanctity of jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. The comments posted on July 30th, 2024 reveal, I can't wait to see this, at 10:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, That Hoodie Guy posted a comment stating, verdict incoming. 25, That Hoodie Guy posted a comment saying, per sources, 5-1 guilty with the man stuck on not guilty or manslaughter. At 27, That Hoodie Guy posted, my sister snuck a flip phone in. What? That Hoodie Guy posted, I'm the brother of one of the jurors. Just text me this. Per sources. 5-1 guilty with the man stuck on not guilty or manslaughter. Per sources, it doesn't sound like his sister is in the jury room. It sounds like my sister snuck a flip phone in to the court, maybe? You can have a phone in the court, though, but you're not allowed to use it unless you're doing court, like to try. I don't get it. At 28, That Hoodie Guy posted a comment stating, my sister snuck a phone in. She texted me, 5-1 guilty, may compromise on manslaughter. At 10:30 p.m., a mere 2 minutes after That Hoodie Guy posted that the jury may compromise on manslaughter, the jury returned a compromise verdict on manslaughter. The timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that Hoodie Guy's information originated from within the jury room. During live deliberations, the court, the man stuck on guilty is very specific. I wonder if that ends up being true. But I mean, I don't know. As somebody who speculates a lot, I remember the Karen Reed jury, and we all were like, the foreman, that man, he's gonna hang things up. So to be specific like this isn't necessarily like, there are a lot of autists in chat who want to be like, ding ding ding, I nailed it 100%. So they go out of their way to like put in random details, and that randomness may become accurate on the off chance. Okay, so this is the same argument about juror misconduct. I think that the cell phone one is kind of weird. Here's one. Cell phone during deliberations constitutes jury misconduct. Obviously, that would be true if that were true. Her text said from sources. She didn't say, like, if it didn't say from sources, the rest of the information is like, damn, she really fucking dropping time in the jury room. But the other jurors would be there like, hey, you can't have your phone. Like, I don't get it. This is reach. I don't know. I think she probably, next time she's not getting manslaughter, she better be careful. Well, okay, that's it. There is a case. I was reading it earlier. It is Rodriguez v. State. This is Florida. This is the appeals court, 3-judge panel. And 2 of them agreed, 1 dissenting, that this, that there was, I don't remember the word, I don't remember the word, but there was shitty conduct in closing arguments that was inappropriate. So let me read this to you. Here's what they overturned and why. Marco Rodriguez appeals his conviction for lewd and lascivious molestation. The jury may have reached the proper verdict given the evidence in this case. However, there's no doubt that appellant was denied a fair trial due to egregious prosecutorial misconduct compounded by defense counsel's unexplained failure to object. We are compelled. So the attorney who filed the appeal is not the one who sat in court not objecting. That is different in the Benefield case. Benefield's attorney is the one who sat there not objecting the entire time and now is saying that it was misconduct. So that might be where this one's a little bit different. Appellant's retrial is not just a do-over. The victim, the child, once again have to tell her story. I'm not going to read all of this. It's actually really fucked up. He was accused of doing something with a 5-year-old, and that didn't come to light until that 5-year-old was 15, and he was accused of doing something else. He admitted to the doing something else. It was minor compared to the 5-year-old allegation. And so he was referred to as, that's all I'm going to really say, but it's probably on here. But says, a criminal trial is supposed to be conducted in a neutral arena in which both sides offer evidence for the jury's consideration. Closing arguments is an opportunity for counsel to review the evidence and to explicate those inferences which may reasonably be drawn from the evidence. If it is the responsibility of the prosecutor to seek a verdict based on the evidence without indulging in appeals to sympathy, bias, passion, or prejudice. If the prosecutor makes clearly inappropriate comments during closing arguments, let me just stop here. This is the appellate judge telling them why he's sending this back for a retrial. So this is Florida appellate court's thought process. If the prosecutor makes clearly inappropriate comments during closing arguments, defense counsel has an affirmative duty to contemporaneously object, both to preserve the issue for appellate review and, for an equally or perhaps more important reason, to give the trial judge a chance to remedy the potential harm by instructing the jury and avoiding its repetition in that trial. The trial judge should not only sustain an objection at the time to which improper conduct when objected is offered, but should so affirmatively rebuke the offending prosecuting officer as to impress upon the jury that gross impropriety of being influenced by improper arguments. Appellant was on trial with regard to alleged specific incidents of sexual molestation or abuse committed when the victim was 5. The charged criminal conduct concerned allegations of appellant for, okay, I'm not going to read that. Okay, so that is just the story that I told you before about it happening 10 years later and coming to light. The prosecutor's initial closing arguments fell within the anticipated and acceptable scope of review and commenting on the evidence, the relative credibility of the victim and appellant, and a discussion of the verdict form. However, during his rebuttal closing argument, the prosecutor strayed from acceptable zealous representation, repeatedly crossed far beyond the outer limits of acceptable argument, while venturing deeply into the realm of prosecutorial misconduct. Unfortunately and inexplicably, defense counsel sat silently by, never objecting, during the repeated improper comments made by the prosecutor. Thus, we must consider whether the prosecutor's inappropriate remarks made during closing amount to fundamental error. Fundamental error in closing arguments occurs when the prejudicial conduct in its collective import is so extensive that its influence pervades the trial, greatly impairing a calm and dispassionate consideration of the evidence and the merits by the jury. The prosecutors repeatedly referred to appellant as a pedophile Inflammatory labels by a prosecutor by describing the defendant are improper invitations for the jury to return its verdict based on something other than the evidence in applicable law. Vituperative, there it is, vituperative or pejorative characterizations of a defendant are not acceptable tools to be implied by the prosecutor. Okay, so in this example, it is vituperative to be called a pedophile, which I would agree. I'm not so sure it's vituperative, meaning cruel or extra harsh, to say that they are manipulative. I don't feel like those are in the same category. Calling appellate a pedophile was clearly designed to inflame the prejudices of the jury and constituted impermissible attack on his or her character. Referring to defendant as pedophile suggests the defendant has engaged in repeated abuse of minors and raises a profiling argument, namely that because he is one, it is likely that he would molest children, including this specific victim, which I feel like is fair. Obviously, they can't be fixed. But here, the prosecutor referred to appellant as a pedophile 7 times, providing far greater potential for unfair prejudice than a single such reference might. The prosecutor crossed the line again in closing by making the well-known and completely inappropriate justice for the victim argument. I didn't know that this was not something you should do. So this is not okay in closing. And they said, the criminal justice system does not exist only to protect the rights of defendants. There's another person in this equation, and that's the victim. The victim has a right to justice just like he does. Equal justice under the law applies not just to defendants, but to victims as well. He's had his day in court. It's time to give the victim her due. It's time to give her justice. A prosecutor's request that the jury show sympathy for the victim is clearly improper. I didn't know that. I would have never known that. That is crazy to me. But I guess they should have got that through during trial, and now they just have to arrange the facts in an understandable story without using bias or feelings or lies. Interesting. Very cool. Such statements have been, is this cut off? Have been uniformly condemned because they may inflame the minds and passions of jurors. Such arguments have been condemned as unfair, intemperate, and unethical. The potential harm of that argument can be sufficiently ameliorated only where such comments are isolated and are met by timely defense objections, which are sustained by a trial judge who then instructs the jury to disregard the comments and admonishes the prosecutor to cease. Here, there were no objections, the curative instruction, and no rebuke of the prosecutor for repeatedly crossing clearly established lines. Further erode the fairness of the trial. During closing arguments, the prosecutor misstated, misrepresented, and/or inaccurately recounted certain evidence, including repeatedly saying that appellant had admitted to several specific inappropriate related activities with the victim, when in fact appellant had consistently repeatedly denied them. Misquoting a defendant or implying a defendant said something he or she did not is misrepresentation of the evidence, as the Sixth Circuit Court of Appeals explained. Misrepresenting facts and evidence can amount to substantial error because doing so may profoundly impress a jury and may have a significant impact on the jury's deliberations. For similar reasons, asserting facts that were never admitted into evidence may mislead a jury in a prejudicial way. This is particularly true when a prosecutor misrepresents evidence because a jury generally has confidence that a prosecuting attorney is faithfully observing his obligation as a representation of sovereignty. What they misrepresent? Oh, they misrepresented the bullet going in and out, and allegedly, and they say that they misrepresented statement about the stalking. They said that they misrepresented the May 4th who wanted sole custody thing. I wonder if that's enough. I wonder if that May 4th one is enough. I wouldn't think so, because either way, it's her trying to get sole custody, which is the state's case. I don't know. There are more examples of the prosecutor approaching or crossing line of proper closing argument by repeatedly calling appellant a liar, including appellant's position with sarcastic remarks and comments. Here in the footnote it says, it may be acceptable for a prosecutor to argue that the defendant has not been truthful and even use the words lie or liar if the evidence supports the argument, as long as the prosecutor does not invite conviction based solely on who is telling the truth. The jury is instructed to reach its verdict based only on evidence and the law. Each of these comments invited the jury to return a verdict for any number of reasons other than proof of guilt beyond a reasonable doubt. The prosecutor's continuous and varied improprieties here raise the concern that this may not have been merely an isolated example of understandable, if inexcusable, overzealousness in the heat of trial, but rather suggests that the improprieties may have been deliberately calculated to accomplish just what representatives of this state cannot be permitted, inducing a jury to convict by unfairly prejudicing it against the defendant. While wide latitude is permitted in closing arguments, this latitude does not extend to permit improper argument. As we have stated for decades, we expect and require prosecutors and representatives of the state to refrain from engaging in inflammatory and abusive arguments, to maintain their objectivity, and to behave in a professional manner. The general rule is that the failure to raise a contemporaneous objection to those comments constitutes a waiver of the right to claim error on appeal. Appellant offers no explanation to why defense counsel failed to object to many improper remarks made by the prosecutor during rebuttal closing arguments. The sole exception to the general rule is where the unobjected to comments rise to the level of fundamental error, which has been defined as error that reaches down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. I don't think they reached that. Where prejudicial conduct, except for maybe that juror, when prejudicial conduct in its collective import is so extensive as to pervade the trial, the new trial should be awarded regardless of the want of an objection. Okay. Taken individually, in a different case, the prosecutor's comments may not have been so egregious as to warrant reversal. However, the remarks must be viewed cumulatively in light of the record in this case. Okay, I guess we'll know that. Since there must be a retrial, we advise the attorneys to prosecute, defend to carefully read our opinion and the many important cases which we have cited, so that there will be no doubt where admirable advocacy ends and inappropriate, unfair closing argument begins. Armed with that knowledge, the prosecutor can zealously pursue justice, avoid snatching defeat from the jaws of victory, and dispense with a meaningful discussion with the Florida bar or a logical professionalism panel. Likewise, well-informed defense counsel will be positioned to effectively advocate for appellant by contemporaneously objecting to any perceived inappropriate arguments. Further, we note that trial courts have a duty, even without hearing any objection, to bring a swift and sure end to prosecutorial misconduct in closing argument, especially when it becomes as frequent and flagrant as in this trial. Oh shit, so basically they're saying, hey, even if the judge should have known better, basically, the judge could have said something. Finally, we also have a duty to take appropriate action concerning what we perceive to be several clear departures from professionalism and possible ethical violations on the part of the prosecutor. If this argument had taken place in our court, we may have been able to take appropriate action to determine whether the prosecutor's lapse in professionalism was intentional and deserving of some sanction, or whether it would be better addressed by strong rebuke from this court. However, we did not have the opportunity to directly address the attorney or the conduct. Accordingly, the action we take is to order the clerk of the court to provide the Florida bar with a copy of this opinion, a copy of the trial transcript, and a letter identifying the attorney who prosecuted this case on behalf of the state at the trial court level, so that the bar or on its referral, the Ninth Judicial Circuit's local professionalism panel can decide how to best address this lawyer and the unfortunate conduct. Listen, Florida is like my favorite when it comes to justice. They publicly shame their attorneys when they fuck up. I don't know. I really like how they hold their attorneys' feet to the fire. Feet. Oh boy. How long is this? Oh, it's it. Oh, there's one dissenting. I respectfully dissent because, in my view, the unobjected to statements made by the prosecutor, although improper, do not rise to a level of fundamental error. So if there's one judge that thought this was all bullshit and should have been fine. So, well, I've been at this for an hour. Surprisingly, I didn't think it would take that long. I think I'm going to end it here. How do you feel? Do you feel like Ashley Benefield's getting a new trial? My money would be on possibly, I don't know how much weight the juror 15's issues were. I have no reference on that. So possibly that could rise. I don't know if calling, I don't know. I'm excited to see this. I want to understand how justice is going to work in this case. So stick with me. As this updates or, whatever happens here, I'll make a new video.